All right, guys. It's now 11:57. It's 11:57. We're going to start 12 o'clock on the dot. We are live, if I'm not mistaken. And there's about 2.5 minutes left. So I'm logging on, I'm logging in, and on the dot 12 o'clock, we'll start with this presentation. And first we'll go through the house rules that I have to run you through quickly. And then we can start with this, to me personally, very exciting presentation on contracts. It's something I enjoy tremendously. So yeah, there's 2 minutes left. We'll just wait for everybody to log on. We are live here on my side. The dot is red, the camera is on and the mic is on. And I can see there's a lot of people already on the site. So yes, we've got a short while there, so get your coffee or your tea ready. Get into your chair, your comfortable chair, not the one you're going to fall in asleep. But yes, it is almost about to start. And these webinars have been rolled out with Law Society Lead. And they've become very popular. Presenters like myself, from judges to advocates to attorneys, as well as other professions and qualified people from time to time to come and spend a little bit of time with you. So we're just waiting, we still have a minute to go. And the moment that minute arrives, I don't want to start on the second, before the second, on the hour. So that we can then, I'll introduce myself and we'll get going and we'll enjoy this. I'm not coming here to present something I don't enjoy. I come to present something I enjoy a lot, and basically under the heading of drafting. POCs, founding affidavits, policy documents. I like to research, I like to draft. Draft is a skill that I have obtained through the years of practice. Not being clever, no intelligence, not necessary. When I started out, the first one I ever did was a POC, a particulars of claim under an action procedure, combined soundness medical negligence. And it was a disaster so many years ago. Everybody laughed at it. And it was there where I decided I'll become good in drafting contracts, any kind of thing. So here we got 20 seconds there. And then I'll introduce myself. We'll start with the house rules. And we will get down to business for the next 2 days. We have an appointment with each other from 12 o'clock. And we're going to enjoy it. I enjoy what I do, and I hope I can instill that in you too. Transfer that enjoyment of what I'm doing. All right, it's 12 o'clock. My name is James Clark. I'm a practicing advocate. I think it's always important that we announce ourselves correct, because a lot of people always have the wrong understanding that they're listening to a pure academic. We're practicing advocates. Civil litigation, criminal litigation, contracts, you name it, we do it. And been practicing for many years. That's me, but more than enough about me, because this is not about me. This is about you. So very quickly, as time is of the essence, it's only 2 hours and then extra half an hour if you use it. We'll see if we use that. I just want to go through the house rules with you. It's imperative that we do that. Your microphone is muted throughout the webinar. Please mute your microphone. It's a disturbing a noise pollution that distracts and interferes with the training. Your camera is turned off. See screenshot below, and ensure that your network connection is stable. So that's one of the problems we have with stable connections and load shedding. So make certain, if you can, we know it's not always possible, to have that secure connection. Eskom might implement load shedding. I'm not even going to talk about that. And try and find an alternative. If you have a cell phone, most probably you can log on through that cell phone onto this link, and you can still enjoy that. I've had people literally traveling in taxis enjoying this with headphones, but of course muting the background. The lead said I might record a webinar for Q&A purposes. Lead has a quality and assurance department run by Mrs. Tasha Rustov. She's the manager there. And so this will be recorded, and they will have a look at this. All right, I've just received a statement here about the recording of the QA purposes. According to the company policy and copyright protection, recordings will not be made available after the webinar. All right, but that's fine. No, that's fine then. That is what the one. This is recorded, but it's not being made available. We know that, so that is fine. So just also take note of the fact that it is not for your availability; it's for QA. That's why it's like that. So don't worry about it. That's the way we've always been doing it. It's not available. You have the booklet, and you are listening to us today. So that's fine. We understand that. Thank you, Stephanie Petersen. She is then on control here at my back. And I've got a co-pilot flying this with me, Merlin September, on the other side of the building. So we're quite a big group of people sitting on this. And then, of course, we are monitored by the QA department to make certain that we meet the standards that they desire of us. Questions may be asked at the end of the training. That's the last 30 minutes. I just want to change that. I have another way of doing that. What I usually do is you can send your questions per email to Merlin September. And then after the 2 days have passed, what I usually do is I take it to my chambers, and within a day or two, I distribute it through Merlin September to everybody. And I built some more meat into it. We had very good feedback on the previous courses last year. As an advocate, I'm in that legal opinion format. So if you have questions, I like to answer them fully, trying to assist you to get where you need to be going. So, all right, that's then important there. I just want to see here what else is important here. No cancellations will be accepted at this late stage, unfortunately. We had somebody phone, I think she's online, she's an attorney for 7 years, and welcome here if you are online. You remember, we are the presenters. We don't have any say on the administrative functions and how this institution is operating. So that's just important for me to state that. And that specific individual, I hope that you will find benefit from this. I personally believe you will, actually, because there's a lot of things I say about this that is actually different. You'll find attached material. You're welcome to print the material you have received, etc., etc., and you can deal with that in that manner. That's your material. Of course, you cannot sell it, etc., etc. You all know about that. So yes, that's it. Points 1 to 8. If I scroll down, I don't see any other house rules here that I have to deal with. Just let me have a look. There is a page button here, and the next page then starts with this course, and then that's precisely where I'm going to go then. Let me just switch over so that I can have this. There we are. Ladies and gentlemen, basic contracts. Practical drafting skills for contracts. This is a subject that is very interesting. And all the people that is registered for this subject, they're not necessarily attorneys, advocates, whatever the situation may be. They're not necessarily even in the legal fraternity. They might be people from the commerce, in the economy out there, and they might be credit managers, credit directors, anybody within a private portfolio without the legal field. So this is something I like to talk about. It's something I like to lecture upon, because this is a big part of my practice. A couple of things in my practice, well, let me rather say it like that, drafting is a very big part of my practice. And that's also where I generate most of the time the biggest income now that I'm getting older, and I don't want to fall over court rubble in the lower courts and so on anymore. And so drafting is very important to me. Drafting has been important in my chambers for a very, very long time. And there is really a benefit in knowing what you're doing when you're drafting, especially in terms of contracts, from the beginning, chronologically and going to where you are going. And just that can just be substantiated in all the court cases in this regard I've done over the years, where contracts are not drafted correctly or they lack the mitigation of risk, and all of those things we'll be talking about in the next 2 days. But you must have a passion for this. And if you are a newcomer, I want to say to you, you mustn't fear drafting. The very first time when I was a pupil at a Pretoria bar, my junior master, I won't mention her name, she gave me an instruction. The first day I was ever there, I introduced myself to my junior master, my senior master, and she said, here's the particulars of claim, here's the case, here's the facts, here's the file, draft me a medical negligence particulars of claim, and they left. They went somewhere. And I was very excited because you're a pupil, you're new, you're changing careers. I was a businessman all the years, and I started drafting, and I asked a little bit of help, and I looked into a book of 2 that they handed out to us. And when they came back, it was the biggest joke under the sun. Don't worry, I'm not upset about it. I'm not accosting them, but it was a joke. They laughed at what I've done. And, you know, that's where I decided that I will make this one of the best and productive service deliveries within my chambers. And through the years, I've literally fallen in love with drafting complicated particulars of claims, founding affidavits, anything basically that goes with drafting where I can lock my door and I can say to the front desk personnel in my chambers, leave me alone for 2 to 3 days. I don't want to see anybody. I'm working on this. I'm drafting this. It's become a big part of me. And I enjoy delivering a good product. Now, enough about that. There on page 3, let's go there. And the first 2 pages is a little bit just an introduction, a little bit academic, and then we get into. Under introduction, basically what we are saying there is that you live in a world that's becoming modernized, and it's also moving into space out there beyond the barriers of Earth. And all of this has to do with legislation. There's nothing you can do about it. Through the years, legislation has been growing and growing and growing. First, there was no computers, and later there was computers, and when there was internet, then we needed legislation, Electronic Communications Transaction Act, and so on, and all those things to navigate legislations. Yeah, we as humans interact with each other on the foundation of a modernizing world ongoing. There is nothing, literally, that you can occupy yourself that doesn't have to do with an agreement. From your marriage, the way in which that's done, from buying your TV on credit, house loans. If you're a practicing attorney, those mandate, those agreements, those fee agreements. We worked with a lot of attorneys on them last night and all the requirements there. We'll talk about them a little bit in here also later on. And everything you basically do is connected to a contract. Whether it's verbal or whether it's in writing, and of course writing electronically via by that implication too. That is where you are in this world. The moment you are of age, there you go. And even if you are not of age, then we are stuck with issues like ratification, emancipation, and all of those things. And even before you go of age, then still you're already busy with contracting out there. You can be involved in contracting out there. And contracting is a very big part of your daily lives. There we are sitting now, listening to me. Maybe you're an employee relationship, and that means that obviously you're involved in an agreement there. A written agreement by implication, out of a written agreement or a verbal agreement, whatever the situation might be. And of course, agreements by enforcement of legislation also. And in the advanced courses, we'll go deeper into that. All right, so everything is linked to contracts and agreements. And that's why even if you're a layperson and you've registered for this course, you will have benefit here. You will learn things here that's important. Even if you go to Westbank and you buy a vehicle and you go through it, you'll be able to say to people, but this surety, that session, this agreement under the National Credit Act, why does this look like this? You can ask questions because now you are informed and empowered by knowledge after these 2 days. Page 4 there, on page 41, the requirements for a valid contract. And this is basically 101 University, and it's the only page that actually is started on that foundation. But we need to do this because so many instructions in the past I have received and I've seen, but there's a lacking in contractual capacity. If you look on page 4, you'll see the consensus basically has to do with the meeting of the minds. Contractual capacity issues arise. Lawfulness. If we talk about legality and you talk about lawfulness, then immediately those of you that is experienced, esteemed colleagues of mine, I'm sure there's very senior attorneys on this course too, because they just want to get back into it, just want to listen to there's something new coming out. You've got attorneys that's been practicing for 15, 17 years that attend the beginner's course, just to make certain that they know about the newest stuff under a beginner's course. Of course, when you go advanced, that's different. So under legality, you think immediately National Credit Act. You think immediately POPIA in terms of what you should draft into a contract in terms of the protection of personal information. So there's a lot of things under legality that's important. So it's just not the academic 101 approach this. If these things are not in a contract, and I've seen it so many times, then there's issues later on when we go into civil litigation and enforcement of contracts. And then, of course, physical possibilities. You must understand that the contract must be physical possible. You cannot engage in a contract that is impossible to engage in. It must be physical possible in terms of the performance rendering thereunder. There's a lot of things just impossible, idiotic to say the least, and you won't be able to contract on those foundations. And then formalities back at the National Credit Act, for example, your agreements must be in writing, etc., etc. So you actually, in law, I used to always say to students years ago on a part-time basis when we do this, that you have 4 requirements. Your requirements for a valid contract is consensus, contractual capacity, lawfulness, legality, and physical possibility. And in the event that it's necessary under legislation, then formalities, the 5th one, would jump in there. So that's it. That's 101, and that's where we stop that. All right. Now, let's start with the practical stuff, the stuff we actually enjoy. Let's start drafting. All right, there's always a beginning with everything. And if you approach contract drafting from the beginning to the end, then you will have a good experience and you will grow in drafting. In the beginning years, when I used to put up contracts, I used to have a notice board in my chambers, a very big one, and I used to plot the road after instruction, how I want to build this contract, and I would draw lines and I would almost work it out mathematically in terms of how I want to do this contract. And I did that for 2-3 years, and afterwards it was not necessary anymore because I gained experience. Right, the general structure of a contract. And at this beginner's level, and even at the advanced level, let me impart upon you, this is the chronological way in which I advise you should approach a contract when you draft it. If you follow this guideline, it will be fine. Why am I saying this? How many times have I sat in a boardroom with an attorney of record and we have a breach of contract or whatever the situation is, court case coming up, and he wants to use me in that court case, instruct me, and I just sit there and I page through this contract, and I would usually ask, who drafted this? Sometimes it's the people sitting in front of me, but I said it was an attorney that drafted it for them 2-3 years in a row. And the first thing that strikes me is the chaos, the anarchy in how it's set up. There is a flow of information chronologically in a contract, and I'm going to try and impart it upon you through this 2 days. The first is the heading of a contract. Now, without even looking there on page 5, you can go and look at it. The heading of a contract is very important to me, because for me, it stems directly back to consensus. Consensus is the meeting of the minds, and that's why very early in drafting of contracts, I understood to move away from short headings. And there you can see it. Look there under paragraph 3.1 to give you an example. Purchase of a vehicle, movable property. That's a good heading. That's a good heading. There's nothing with it. We could maybe say there, but we have the word purchase agreement there. That's fine. But it's a good heading. But for me, it doesn't really say what we are busy with. And I'd rather say purchase agreement, purchase of a vehicle being a Nissan LWD NP200 silver with registration number so and so. Now, you don't have to do it like this. I'm trying to impart a concept of consensus with you. I've learned very early that headings are very important. And when you go into court and you argue about a concept like, but I didn't understand what I was signing, and in the times we are living in, I don't really understand that argument, but it does happen so much, then you can say, but look at the heading alone. The heading might not be part and parcel of the content of the agreement, but if you observe the heading, we have consensus. You knew precisely what you were getting into. And the last thing I want to say about headings then is the following. Make certain that the headings is also not overbearing, but don't go in for complicated headings. Make certain that when you give an agreement a heading like we've done it here, it's in good English, it's understandable English, there's no Latin in it. We're not talking about terminologies that only us as legal people and legal profession and practitioners would understand. So the first thing I'm teaching you today is start with your heading, and in your heading lay a platform for consensus, and you will see how intellectually it works in on you when you start drafting this contract. Because every day when you work on it, you look at a heading and you know where you're going with it. Don't just call something a purchase agreement. Is it movable? Is it immovable? And if you want to go into more detail. Subheadings in a contract. Now, as a counsel that's now already senior in my years, I just smile upon contracts that sometimes comes over my desk. I have to litigate on or even write legal opinions, whatever the situation would be, that doesn't have subheadings. I can't believe in the times we are living in that a contract like that can be drafted by experienced people. People that even has a year of experience as an attorney or an advocate should know better than to draft the contract without subheadings. So a well-drafted contract will always have subheadings in it, and those subheadings will pertain to the content. How many times have I seen a contract where there's a subheading? I read the 4 clauses under that subheading, and there's one clause that when I look at it, I know for a fact it does not belong there. It belongs somewhere else in the agreement. So when you draft, you must pay attention, and your content under your subheadings in your paragraphs must be relevant to the heading. Now I know a lot of you are going to scream and say, but why do you lay so much emphasis on it? Because we build on the interpretation, that clause in there that says, well, you know what, the headings are not relevant to the interpretation of the contract. That doesn't go up with me at all. I mean, if you put a product on a table, even for yourself, it must make sense. And by the way, if you lack to build that clause in there, you might have an interpretation in terms of your heading, and then you might have a problem. But it has to do with a chronological flow of information. It has to do with neatness. You're proud of the work you're doing, and everything goes where it's supposed to be going. All right, good. So that's nice. We have a heading. We know that the heading stems back to consensus. We have subheadings. We know that also has to be relevant. In terms of consensus, that's not out of the window. And we know that everything that we draft under that heading must be relevant to that heading. Otherwise, we must put it somewhere else. Parties to the contract. All right. Here we can write books about parties to the contract. The first things to parties to the contract is capacity. Now you see now how those page 3, 101 requirements are starting to face into the practical work. People that gets into a contract have certain capacities. Are you a natural person? Are you a juristic person? If you are a person that is a director and a juristic person, or you are a trustee, whatever the situation might be, that must be drafted into your contract. Now, when it goes to parties in a contract, and when I have companies contracting with each other, I build everything in there. Now, please also make me a note there. Make a note there if you have printed this, and if you can make an electronic note, make a note there that, and this is maybe where this can go a little bit more in terms of a beginner for people that feel that, well, I know one person felt that maybe this is not for her. She's advanced, but this is important. I never draft any kind of contracts for juristic persons as well as natural persons if I have not done a wind deed print on them or a ghost practice print of them or whatever the situation. I don't do it, especially when I work with companies, because I've had so many people, attorney gives me instruction to put up a contract. I'm busy with the contract. I ask for a wind deed printout on the companies, and suddenly I see, but this director resigned. Where is his capacity? How is he involved with that? Where's the resolution that instructed him that he has the power to give these instructions? I've identified so many fraudulent aspects in the past because of the way I work before I get too deep into it. So when you put up a contract in terms of the parties, get a registration number, do a wind deed, use that spelling there, use the information at CIPC that's correct there, make certain that the people that's giving you the instructions got the power to do it, and make certain that their capacities are indicated correctly in the contract you are about to draft. And also make certain, if you go to page 6, you will see there on the top, we talk about service provider and client in that last paragraph on a paragraph 3.2. Also make certain that you also use the correct terminologies. He's a service provider. So we have capacity. He might be a director representing the company in this contract, but this company is the service provider to that company. Are you with me? So there's a couple of things when you cite parties. Whenever I get a contract and I see there's just a name and an ID number, or just a name and a registration number, sometimes not even stage, I smile upon it because I know whoever drafted it didn't do it right. Now you would say to me, but okay, we have got duly authorized to sign at the back. Nonsense, because nonsense under the sun. You must cite your parties correct, and that then you still type in that at the end, because yes, indeed, it does cover you in terms of fraud. There can be a crawlback, there can be a hit back, but you got to do it right from the beginning to the end. And I'm very strict to myself. When I draft over and over. And to the attorney of record, and sometimes the attorney of record say to me, well, as you are sending the first draft back to me, just CC or cite the client also, so that at the same time we can get it and look at it. And sometimes I go through 7, 9 drafts before I'm satisfied. And they talk to me and I ask a lot of questions. I do not guess when I draft a contract. You'll never find me guessing. That's just out of the box. I don't guess. I ask the stupidest questions you can imagine to get information. And in a boardroom, I had a habit always of walking in there. When I was already senior, I would walk in there, say to the engineers building buildings, and we're working on contracts and stuff. I'd say, listen, I'm stupid. I might be good in my field, but I have no idea what you're doing. So when you explain what you're doing and how it pertains to this contract, I'm a layperson. You really need to look at me as a subgrader. And then when they explain to me and I grasp it after 100 questions, now for the first time, I can put it in legal jargon. And now I can sit down and I can start working on somebody's contract or litigate on somebody's contract. So that's very important for me. And these things are very important. Your citations must be 100%. Mine's are, if you can see me, I don't know if you can see me, mine's are that thick. It's about sometimes 5 to 7 lines long. I try and miss nothing. I try and do it as well as I possibly can. So let's quickly see. We've got headings. We've got subheadings, and now we are the parties division. So we've got a heading. We're going to do this in subheadings, but before the subheadings start, we're going to cite the parties. All right, let's go on. Let's not stay too long on this. We're already on half an hour. Agreement in a contract annul. Ladies and gentlemen, there's been a lot of court cases about this. Just after you've done the parties now and you're satisfied, you cite all the capacities and the terminologies. Because if you look at provider and client, that is the terminologies you're going to use in your agreement so that you don't have to use that party citation, that big party citation every time. So that's also a reason for that. Then just below that, you must type the following in there, as we've done it in paragraph 3.3, wherefore the aforementioned parties agree as follows. There's been so many court cases about this. And luckily, the courts has taken an approach to it in terms of, well, you know, by logical implication. If you sign a contract, you agree to it. But, you know, we counsel build arguments. We are tedious in building arguments. And I've gone up against a colleague many a time where they come with an argument, well, that's not there. So how do we know what here that you actually agree to? And nowadays, that does have some credibility, doesn't it? The experienced people listening to me will say, yes, it does. Because we know under the National Credit Act, for example, that if there's any kind of negative clause in an agreement, but it's not unlawful. Listen to me. It's a negative clause in a National Credit Act agreement, but it's not unlawful. It's a little bit more pressure is put on the client, but it's not illegal. Then you all know that's in this field of contracting that it must be signed. So you make it bold, you put a line around it, make it gray in the back like I do it. And then that clause, apart from the fact that everybody is still signing at the end of the contract, at the bottom of every page, that clause has to be signed off individually also. And then this makes sense. This starts making sense. Wherefore the aforementioned parties agrees as follows, that's actually indicative of the fact that what follows here, everything that follows here, until the moment I sign, we agree upon. And so that's an argument you might be able to raise there, but you will not be very successful under the National Credit Act because that's by legislation, the enforcement there. So you've got to have the scene. I've seen great arguments on this. And every now and again, some judge would rule in favor, shockingly in favor of, well, it's not in there, so you guys have a problem. So please, there's another way you can put it. You don't have to put it precisely in these words, wherefore the aforementioned parties agree as follows. I've seen other people make it shorter, other people make it longer, but there's a good way you can work on that. All right. Quickly, let's recap. Heading, parties. And then we have this, wherefore the aforementioned parties agree as follows. And now we are starting with the subheadings. And the first one, if you can call it a subheading, an index, is I personally never put an index in a contract if it's less than 50 pages. And it's kind of the norm out there, and we've been taught that for years. So you got to decide for yourself. The bottom line is, if a contract is too long, you need an index. Because the index has got many benefits to it. First of all, when we go to the index, we can immediately say what is the content of this agreement. If we double check it, or if I put out my first draft, the attorney of record, the client can say, I've gone for your index, please, I don't see this, I don't see that. That's one reason for it. The other reason for it, it is neat, it shows you the structure of the contract, and we can get immediately to clauses we want to get immediately to. We don't have to page and read and read and read. So when we are starting to put up contracts in the format of a book with many annexures and clauses and stuff, I have drafted contracts over 100, 120 pages in my time, and then we will build an index in there, and that becomes important there. There is no reason to do it for a contract that's 3 or 4 pages long. It actually defeats the purpose, if you ask me, but that is also a personal choice. There's not a law that says you mustn't do it. I just think it's a waste of time to do it, in my my personal opinion in my experience through the years. So there we are. That's the first subheading, index. The second subheading, something that's become very popular in your time, is the preamble. A preamble, according to me, is just another word for introduction. And you can read for all of this in your own time, but preamble basically has to do with the introduction of the contract. There, if you read through here, the preamble is usually giving the heading recitals, whereas, or background, properly written in all caps or bold. That I never do. That I never do. I never do the content of the preamble in bold. You can do that if you want to, but my headings are always very neat. They underline, they bold. My numbering is always in bold. But we'll look at that tomorrow. So preamble for me is important to introduce the contract. A little bit of history, maybe a little bit of facts that we just want to bring into the preamble. And the preamble cannot be on the foundation of being repetitive to what's in the contract. That's got no benefit. You're wasting your time and you're repeating yourself, and at the end of the day, you're going to look stupid. So that is not a preamble. The preamble is maybe there was a little bit of history and there's the facts you want to bring on his attention. And something I sometimes built in there is that the people are desirous to engage in a partnership, things like that. I would put in there, and a little bit of the history where they're coming from. But I also don't make a preamble too long. If I think about my preambles, I would say that about the longest I've written was half a page, 4 paragraphs, 3 paragraphs maybe. And you can go through that in your own time, but it's an excellent strategy. I like doing that because later if there is a problem with the agreement, you can usually fall back to the preamble, say, but hey, it took us a year to arrive here. That was noted in the preamble. He spoke a little about the history. It looked at a few factual statements that we won't be using in operational clauses within the contract. And then we can always say, but from that point of view, this is where the litigation is going to go, etc., etc. So something you can look at, if you're going to read it on page 7 at the top there, the third paragraph before we go to paragraph 3.6, a drafter should also refrain from filling the recitals with additional non-key definitions. Don't do that. Please, your preamble has got nothing to do with definitions in any event. And we'll go to definitions in the next section. So that is not why the preamble is here. I've seen a preamble raped a couple of times. I've seen the preamble being repetitive. Why? What is the purpose of that? You're wasting your time. If you're going to use clauses as the operational machinery of your contract, then they're not going under the preamble. But a preamble for me personally is very important. And I always like to write something there. Lay a foundation for what is about to come. All right, so let's recap. We will be recapping until you get nauseous of us. What do we have? We have the heading. We have the parties. We all agree to this. We have the subheading starting with the index, if you have one, and then we rolled out a small preamble then. Now we go to interpretation. Ladies and gentlemen, it's the most amazing thing I've seen in my life that people put definitions and interpretation in the back of the contract. Really? What is that all about? If I'm going to read a contract wherein, take the Companies Act, we'll look at that under advanced contracts. There's stuff in there that's pretty difficult. And next week I'm talking here about shares. And if I'm going to read a contract and there's difficult stuff in there, I'd like to know in the beginning what that difficult stuff means. And that is why my interpretation, you will never find at the end of an agreement. It's just one thing that will never happen. But when you have long agreements and you've got departments, semi-divisions within your agreement, like you've got A, so some of the contracts are like book forms, it's A, and under A, this is discussed, and a big B, and that is discussed. I've done a lot of them. It is all right if you build your interpretation and your definitions into those sections, as long as the content that follows go back in the reverse gear to those interpretations and divisions. So it must be in the beginning. It doesn't help you read something and I don't understand it. At the end of contract, suddenly there's a definition on it. What does that help? It has got no meaning for me. I'd rather like to know what it means. And when I get to say, but you know what? I started reading and there was a definition on shares, ordinary shares, preferential shares, whatever the situation might be. And now I know kind of what it's about. I also know it's there. So I can quickly go back and look again if I don't clearly understand it. And that's how somebody that reads a contract can then be empowered with the content therein. So you can work through that there. Interpretation, also definitions. I don't know why we're falling around. Years ago, we used to say definitions. And now nowadays we call it interpretation. So it was just a culture change there that came around. I must say, You know, I'm an old dog, I'm an old dinosaur, so I'd say definitions is actually explains it better to me. But yes, I am guilty. I've also get into the habit to follow the mainstream, and I'm in the habit of also using interpretations. But I still think definitions is the right approach there. And it's up to you. You don't have to use interpretation if you don't want to, and so on. I also think another reason why maybe we moved into the culture of interpretation is you might see on the shareholders agreements and long agreements that some of this stuff is not pure definitions. Because if I want to define a terminology, a definition defines the contents of that specific word. It's almost like a dictionary definition. But you'll see nowadays we're using interpretations a little bit broader. And maybe that's why we broadened out the interpretation. We would say company means the company name. That cannot be a definition. Company means ABC, company, Pty Limited. So maybe that's why we were using interpretation, because then it's not just flatliner definitions. All right, good. So what do we have? We have a heading. We have parties. We have whereas. We go to the subheadings. We start preamble. Well, we first start index. If that's relevant, we hit preamble and we're off into interpretation. All right. Now, before I move on, keep your interpretation division open. I always draft in this manner. I don't know what I'm going to draft into a contract if I get an instruction. Excuse me. I know the basic headlines of the law, and I know what I want to do with it, and I know what I need to research, especially when I'm here next week on shares, because I'm coupling it with contracts. And what's very important about that, I've put up a schedule for you under the Companies Act and the regulations, every clause that's relevant to drawing up contracts for shares and shareholders. And that's very important to keep your interpretation division open. As I'm drafting, suddenly I use a terminology, or maybe a Latin word, although we're not supposed to. I'm still using something, or maybe a phrase, or maybe I'm talking about estoppel. And then quickly I stop, I go to the interpretation division, I put the estoppel, I give it a definition, I explain it, and I go on. This is how I deal with the interpretation division. I keep on building it, ongoing, until I'm finished with my contract. There's no way, in my opinion, that you can say, well, this is the definitions I'm going to use before you start, and that's all it's going to be. I don't work like that. Now, how do I identify difficult interpretations? It comes from the inside, here, my chest. I'm drafting, and suddenly I think, whoa, I don't think the layperson is going to understand this. I better do something about it. Quickly, back to the interpretation. Just give a good explanation of this terminology, and then I move on. So keep it open. If you keep it open, you won't make mistakes. Right. We go to page 8. We're off to page 8 there, and that is specific terms of a contract. Now, specific terms of a contract, you can go and read there. I like talking. It's all there, and there's more there, but I like talking, and I think it's relevant. I'll read a little bit, but I'm not here to read stuff to, because you can do that in your own time in your office. Specific terms of contract is within the definition of your contract. What type of contract are you drafting? Is it a sale agreement? Is it a credit agreement? Is it the employment agreement? Is it the cooperation agreement? Is it the association agreement? What is it? And in terms of that, then, I just got somebody coming in. Give me a second. Yes?
Your screen is not moving. Are you still in chapter 1?
Yes, no, that's fine.
Okay. Because the people said the screen are not moving.
All right, I understand. Okay. Thank you. They say the screen is not moving. I think it's moving now. One of the reasons your screen is not moving is, although the screen is on your system, I'm working for the book inside of me. Now, that's how I usually work. And I actually told him today I don't want to do that anymore. I want to work off the screen. So let me test this. Let me go to paragraph 3.7. So those people that came in, it wasn't an electronic fault. I'm guilty. I'm the liable one. Are you listening to that? I've got the doctoral. I'm an advocate. I'm guilty. I'm the liable one. Please, guys. These chip on the shoulder with titles we must get away from. We're all human beings, flesh and blood. If a boss hits you, you die. If he hits me, I die. So this was my fault. I apologize sincerely. I'll try to remember to move that screen. Usually I work off the guide, and usually you can actually see my face. I don't know if you can see it now, but that is not important. So that is not administration's mistake. That's my mistake, because I've got the book in front of me and I've got a screen in front of me. All right, so good. Excellent. That's great. So specific terms of a contract. I'm now on page 8, by the way, and I'm looking at you on the screen, and I'm looking at a book. Specific terms of the contract is then your unique contract. You've been appointed to draft this contract. Now, the first thing you do, Listen up, ladies and gentlemen. You might be an experienced drafter. Do yourself the favor of always go and look at the definition of the type of contract you're drafting. Every contract has a definition. And if you don't have a good contracts guide, contact this institution, pay for it, and they'll post the newest stuff to you on the 2020 and 2021. And I know that there's even 2022 stuff that is already ready for next year. So get your definition out. Why? Because you've got to look at all those things like the essentia italia, the naturalia, and all of those things. Make certain before you start drafting a contract that you know what the essential components is that should be in that contract. Because if you don't do it, that contract is going to be void and null and void. It's going to be a contract that can be attacked. There's going to be problems with it. Because if you don't build the essential requirements of a specific contract into that contract, it is not that contract. And that is something you have to look at. And this is the specific terms of a contract, then you have to meet there. And I see here on the screen, if we quickly look there, the middle paragraph on the paragraph 3.7, I am on page 8 now. Such terms and conditions will identify the rights and responsibilities of both parties. This can include general and special conditions. A general condition is one that is common and included in most contracts, and which we'll discuss later in this manual, because according to me, those are not specific terms. They are boilerplate terms, and I'll talk to them about you later on. But the last paragraph there on the 3.7 says to you, not only do clear specific terms help guide performance and limit ambiguity in the event of a dispute, but they ascertain beyond certainty precisely what the parties are getting themselves into. That specific type of contract, the unique contract, you'll see there in the first sentence. Very well, I need to scroll. All right, thanks. I need to scroll. We have a joke there. I suppose we can read that quickly. What if we don't change at all and something magical just happens? I've got one thing to say to you, the mitigation of risk. You might think that's a joke. The mitigation of risk is something that you must always keep in mind when you are drafting a contract. Now, sometimes you are the appointed person to draft a contract and both parties are your clients. That's usually not too big of a problem. I've been in that positions many times. But if you are drafting and has to be sent to another attorney, you must always remember one thing. Nobody comes to you and they're going to pay you to draft a contract with the intention that you must overkill the other side to the extent that the other side will not sign. Who will give you instruction like that? When people come to you, they want you to mitigate risk as effective as you can. But they want a contract, meaning they want the other party to sign it. They want to get into something. They want this contract to roll out. So this is one thing, mate, know there. Do not overkill. Because if you overkill, even if a person on the other side doesn't have a contract, he's not going to sign it. He's going to think you're an idiot because you are laying all these massive, massive prohibitions upon him, and it's totally killing him. So you must be very careful of the line you tread. Now again, this happened with me in the past where I've had clients that says, I want that clause in. There's no ways I'm signing that contract, this detrimental, deadly clause, if you don't put it in with the other party. They requested a contract, I want this in. Then you can draft it in, and then that's upon them. But I've also had my battles in the past with clients. I make them say everything to me in writing. Usually per email, and sometimes per WhatsApp, and then I would just have those WhatsApp print by the personnel in my office and put it on the file. So just to give you a quick example, a testament, drafting a testament is also a contract. It's actually, yeah, it's also a contract. And I had a guy that, it's so stupid. One weekend, his son-in-law came to visit him, and the briar had to be dragged 10 meters away where the people were sitting, and the bribe was going to happen, and the son-in-law was sitting, and the old man had to, you know, move the briar, and he wrote him out of his will. And I still said to the old man, but why are you doing this? He says, well, he has no respect. He's not inherited. He's my son-in-law. He will get nothing. You have to build those clauses in that everything goes to my wife, and it's her estate, not his estate, and all of those things. And who died first? The son-in-law. So when the son-in-law died, what did that clause at the end of the day? What was the benefit of it? But he is the instructor. He wants that in, and then you have to do it. But I want it in writing just to cover me in terms of the contract is not being signed, because this is what happened. What happens if a contract is not signed? What's the first thing that happens? Well, we're not going to pay you because this didn't come off. So please, for my colleagues out there, if you're an attorney or an advocate, cover these avenues. And please, for other people out there, if you're a client, you're going to pay. The services was delivered. And if it's due to your fault, wanting overbearing mitigation of risk in there, then it's your fault if that is not happening. But it can be due to the negligence of the attorney, and that you can pursue through other avenues, especially nowadays under the Legal Practice Act, the new one, and those massive code of conducts. I mean, I loaded all of them on the e-leader platform with the QA manager the other day, and I'll tell you, attorneys must and advocates must nowadays really render a decent service. Otherwise, you don't have to pay them. I should most probably not say that, but it's true. So that's the specific terms of contract. I won't recap now. We'll just wait for another 2 divisions to discuss. We'll recap again, because this is the chronological flow of drafting a contract. There's not really any other way of doing it. We're moving on to the legislative clauses. When you get to the legislative clauses, let me scroll down. All right, guys. Okay. Unfortunately, I see they don't have these little blocks in the corner. I see at night we can actually see what people are saying there. Maybe they're afraid you're calling me an idiot and I'll read it there. Maybe I'll stand up and walk out. All right, legislative clauses. All right, legislative clauses is important. That's your next division. You work with the Companies Act, you work with the National Credit Act, you've got POPI out there, you've got PIA out there, you've got so many acts out there. And when you draft a contract, actually, basically nowadays, if you think about it, what kind of contract would it be out there that's got no law prevailing upon it? I mean, really, think about it for a second. So you've got to do your research in terms of what legislation is applicable, and like under the National Credit Act, what legislation must you draft into your contract? And this is then when you go into legislative clauses. And please remember that it will not always be the National Credit Act. I can tell you now, you deal with POPIA, you deal with the National Credit Act. Now, interesting enough, let's stop the buck there. Interesting question that has come through the years, and people struggled with it years ago, but I suppose everybody knows the answer to it now. When you buy a vehicle on credit, what act applies to that credit agreement? Let's say you buy it for Absa Bank. So the theory around it is, of course, that the National Credit Act applies, which is correct. But is that the only act that applies? What did I buy? I bought a vehicle. What is a vehicle? A vehicle is immovable. What impacts on that? Even if I buy a house is immovable. So if I buy a vehicle, it's not only a personal loan, then the National Credit Act and the Consumer Protection Act both applies. But I just made a mistake, didn't I? Who knows? I just said something that's actually incorrect, didn't I? I said if you take a personal loan, there's nothing involved on the National Credit Act. That is the biggest horse nonsense in the world, isn't that? Because the bank is rendering a what to me? A service. And if the service is defective, that results under the Consumer Protection Act. So a lot of people don't always understand that the National Credit Act and the Consumer Protection Act, in most instances, if not all, runs together. And that is your legislative clauses. You must make certain, especially under the Companies Act, that you deal with those clauses. And I'm telling you now, ladies and gentlemen, if you're a legal practitioner out there, please, you cannot tell me that you can charge under 25,000 Rand for a selling of shares agreement or a shareholders agreement. Let me tell you why it's so expensive. If you go and look at the Companies Act and you work through what I'll show people next week on the shares column, all the information in the Companies Act that most people have no access to, most people don't know about. Not even directors in companies knows what's in the Companies Act. And if you have to draft an agreement like this, you've got to build all those legislations in there. Now here, you can write this down, you can take a tip from me. Listen to what I'm going to say now. I use my contracts to educate the parties. Listen to it. I use my contracts to educate the parties. When I was a young practitioner, I couldn't say I'm doing that. But after years of practice, I've gotten into the habit of building massive contracts, and I educated them. Go through the Companies Act, and I said, this must be in here under legislative clauses. And a lot of the people come back and say, but we didn't know that. I say, well, you've been educated in a contract, and that's also part of mitigating risk, but it's got a bigger part. People think twice to unjustly and unfairly take each other on in terms of contracts. If everything is in there and everybody knows what's going on. So nowadays I'm playing an educational role also. I would never have said that when I was a junior. Never. Because I think it would have been a total lie, because you haven't had the experience to think so wide and to draft so broadly and to understand what you must consider. And your contract is right, because a lot of things that doesn't have to be in there under legislation. You must go and look under legislation what must be in there. Those things must be in there. But I don't follow that route nowadays. With Company Act, shareholders and shares agreements, I put everything in there. And the guys that's with me next week on this webinar will see, I call it the notes on share. We're going to do notes on share, because everybody struggles with shares and how to draft it into contracts. All right, it's now 1:45. We can take a break in 14 minutes. And that's legislative clauses. Right. All right. So let's recap. Be with me on this recap situation. The course's name has got beginners in it. And it's important for me to instill into your mind the chronological flow from a contract. So let's see, what do we have? We've got a heading. We've got parties. We've got whereas, everybody agrees. If, then we have an index. We have a preamble. We've got specific terms. And after specific terms, we've got legislative clauses. Now we go to the boilerplate clauses. Ladies and gentlemen, I'm scrolling. You almost caught me. You almost caught me, Mr. Radi Boshoff and Jarudin Boysen and Mr. Baloyi. You almost caught me. I scrolled. Not that you complained. I'm just looking at a name list. And I don't think anybody complained. I know you just brought it on my attention because it's easier, right? It's easier. So please write there under common terms in brackets boilerplate clauses. That's how I see it. Now, what is common terms? Let's first start there. This is the working machinery of any contract in the world. Ladies and gentlemen, if you don't have the common terms in your contract, you're going to have a defective contract. Now, it is true that all common terms is not necessarily have to be in your contract. But if you want to frustrate me as an advocate that I have to do a case for you, then you must give me a contract where there's no breach of agreement clause in. I mean, I've seen that so many times and it infuriates me. Things like that. And I mean, I can actually not really think about a contract where there should not be a breach clause in it. A whole agreement clause in it, a variation clause in it, a relaxation of terms clause in it, you know, things like that. So the common terms, it doesn't matter where you go, those clauses must be in there. And I'm going to try and, as we work through this, I'm going to try and show you these clauses. We're going to take a little bit of time with these clauses because they're rather important to me, because this is your contract. Apart from your specific contract that pertains to what type of contract you're working with, this is the mitigation of risk. This is the foundation of mitigation of risk. And if you don't do this, then you have a problem. Again, buy the contracts book from this division. You can inquire, I think, from Mrs. Rustov at the Quality Assurance Department. I hope she's not upset I'm giving her name out. But you can buy that book. And in that book, there is a bunch of boilerplate terms there that you can use to really roll out the contract in terms of the machinery that molds it and gets it working. All right, enough said. Whole agreement. There on page 9. The document contains the whole agreement between the parties. No party will have any right or remedy arising from any undertaking, warranty, or procedure which not included in this document. Now, you all come from university, the young guys, and there's experienced colleagues of mine on this. One of the ladies I spoke to, her phone, a 7 years practitioner, says experienced. I mean, she knows this stuff backward, so she'll know what I'm talking about. You'll know that one of the things this obviously is attacking is verbal agreements beforehand. You've been at university, and I'm sure it was if you have a legal degree, it was a university question. Such a clause does not exclude a tacit term in a contract, so take note of that. Take note of that. A tacit term has to do with a term by implication, implied term. Now, I want to say something about implied terms now. Make a note there somewhere. Guys, as far as you can, stay away from implied terms. How do you do it? That's when you want to keep your contract short and maybe you're not getting paid a lot of money to put up a big contract because fees are linked to working hours. That's the way it is. That's the way it works. And make certain that you are clear about everything. Don't leave everything open. I read the contract nowadays through, I draft it 20, 30, 60 pages, doesn't matter. And very quickly in a certain division, I'll pick up, whoa, stop the bus. Everything is right. But this is hanging in the air. With these clauses, we are implying it, but it's not really written in there. But any person with common sense would say, well, you know, it's implied. No, no, no. Don't do that. Don't do that. Rather put a little short paragraph in there and clarify it. So as far as you can, stay away from implied and tacit terms. All right. That is important for me. And what's nice about this guide, as it's got court cases also in here for you that can guide you. Go read these court cases. Yeah, you're shouting, I don't have time, blah, blah, blah. You're not going to do it. Do yourself a favor, do it. Go and read these court cases. They're just going to make you a better drafter. I love drafting. Me sitting here and talking to you about this is for me fun. I'm not constrained in any way or under pressure or feeling, listen, I got something better to do. I love doing this. I mean, you really want, as a legal practitioner, you really want to broaden the horizon of your knowledge about law. Start drafting contracts and see where you land. All right, and then we've got another court case there. You can go and look at that in your own time. That's a whole agreement. It's a very important clause. It basically says that everything in this contract and nothing apart from that, anything else would not be relevant. But then, of course, you've got to look at that court case of 2012. Now, what do I do? Now, listen to this, guys. Listen to this. Let me rather quickly teach you this too. I take court cases like Matthewson versus another Van Niekerk. Such a clause does not exclude the tacit term in a contract. Then I take that court case and I go and see if I can change the implication of that court case by drafting the lacking identification into the court case, into the agreement. I've done it many times. So yeah, I'd utilize this. I'll talk about it. I'm saying about a party categorically has knowledge of such a short court case. I do it in contracts. I said sometimes court cases in there, and they agreed in terms of this is not going to be applicable. You cannot do that under legislative legislations, whereby legislative enforcement promulgated through Parliament in the Act. You have to put you cannot get away from that. But I love taking court cases. I've drafted so many contracts clauses out of court cases. I see what a judge has said. I see the problem identified. I see what he said there. I say, well, you know what? If that is what you ruled, in the next court case, if you do it on this case, I've swung it around, I'm going to do it like this now. Make a note there. A lot of people don't do that. They don't think of doing that. Read a couple of court cases when you get the instruction and see how you can do that. All right, we talked there about variation. That's when you amend a contract. The contract or any part of it can only be waived. Okay, all right, guys. All right, I hear you screaming in my mind. I've scrolled. The contract or any part of it can only be waived, varied, added to, or cancelled by a further written agreement between the parties signed by the parties. Note that variation requirements of certain contracts are dealt with in legislation. Under the National Credit Act, there's a lot of stuff you cannot amend, and that's just the way it is. They also say there, if a clause or condition is only intended to benefit one party, one could expressly grant that party the exclusive right to waive such a condition. The following wording could be used. The above resolutive condition is for the benefit of the buyer only and may be waived or relaxed in writing by the buyer within 3 months after the conclusion of this contract. What is variation about? This is a beginner's course. Variation has to do with the fact that, and this is how I usually do it. Any amendment, any variation of the contract must be in writing and signed by all parties. Bottom line, stop the bus. At this level, this is what I'm saying to you. It has to be in writing and signed by both parties. Signing? What are we talking about? At advanced contracts, we're going to talk about signing. There's different way of signing. So with signing, I mean legal signing. Whether it's with a pen, it's electronic signature, doesn't matter. The bottom line is in writing. In writing? What does in writing mean? Well, obviously, I'm talking about what constitutes an electronic communications in writing. So that's what I'm saying. Must be in writing, must be signed by both parties. Variation, end of the story. And I've done many cases on this. People start fights because they verbally agreed over the phone to change something, and they never did it in writing. And then the other party says, but it was never in writing, so it's not enforceable. And they've never put it in an email or something like that. I've had that a lot in my career. And that's an interesting fight, but usually you win it, except there's really circumstances beyond that a judge is going to look at and makes a different ruling. Relaxation of the terms, there on page 10. Let me scroll down. This is the first time I'm doing the scrolling thing. There it is. No relaxation of the terms of this agreement and no indulgence which one party may grant to the other will in any way operate when you break in 4 minutes, don't worry. will in any way operate as an estoppel. No, go estoppel, go to your interpretation division and tell people what estoppel is about. I mean, a layperson, when you say estoppel, he has no cooking clue what it means. Against the former party, or to be deemed to be a waiver of his rights, or in any other way limit, alter, or prejudice those rights. Let you give me an example. I have a block of flats, sorry. I have a block of flats. And every now and again, people staying there would come to me and they would say, listen, I can't pay the full rent, or I've lost my job, or whatever the situation might be. Can we just pay that the next month, the lacking R1,000? And that is relaxation of terms. So then we say yes. Now listen to how I do it, because this might help you with drafting. When a tenant comes to me in my block of flats and says this to me, I usually say to the front desk in my chamber, all right, I've got a template there. Make them sign it. Make them sign what day they're going to rectify it. I don't just relax terms verbally. That's the biggest mistake you can ever make in your life. Because I let them sign, yes, it's fine. I'm relaxing it only from this date to this date. That's the amount. And then in that template, I have the other working machinery of this contract in there that says, if you don't do it, remember I can do this and that and that. And I keep that document. So that if I later want to cancel or evict or whatever the situation is, then I can use that document. The approach to the relaxation of terms in contracts I've seen is very slack. It's extremely slack. And because I love drafting contracts, I've set up this template. I mean, I've got tenants then, I've got a lot of problems with them from time to time. So for litigation purposes especially, I build up documents. I say, oh, you know, this is a situation. He signed. He agreed. I gave it to him. I was the nice guy, and there you go. So do you see mitigation of risk? Are you getting with me now? I see where I'm going with this. It just doesn't stop there. It goes beyond this. It goes beyond this. So when you draft this contract, you have the relaxation of terms there. You can say to your client, for another couple of bucks, let me draft you an annexure where we say that under relaxation of terms, this template will be used in such an instance. Hey, there's something you can do. I do it, and believe me, when it comes to tenants, I tell you, I'm happy I do it. Right, so they're still busy with boilerplate clauses, breaking in two for you there for a cup of tea. We're going on to jurisdiction of magistrates court. You can call that jurisdiction if you want to. You don't have to really call it magistrates court if you want to. You can decide if you want it in a magistrates court or a regional court or a high court. Just remember the threshold of the court, and we tell you all about them. There you can see 300,000 rand, etc., etc. And you can then decide what you want to do there. But let me read to you the essence of it. Each party consents in terms of Section 45, the Magistrates Court Act 1944, to the jurisdiction of the District Magistrates Court in respect of any proceeding pursuant to this agreement. And that's how you do it. But this clause is wrong, isn't it? Huh? Mr. Mrs. Stefanie Vlies, I think, and we've got Lenton there. This clause is wrong. Why? Why is this clause wrong? Now, you would laugh at me. And I've learned this word here in Mrs. Rustow's office, pedantic. So I suppose I'm pedantic too. I would rather say, and by the way, we prepared this for you. I've learned something in my life, and I do it ongoing nowadays. Each party consents in terms of Section 45 of the Magistrates Court Act 1944. Yeah, as amended. Please draft it in there. Whenever you refer to legislation in South Africa, especially in contracts, please say amended. Why? We're going to sign this on a specific date. And let me tell you, I've brought an argument or two in my time and say, but whoa, you know, we have we can go back in time with this act. It was signed on that date. There's case authority there that says that before this date, that's applicable. After this date, that will be applicable in terms of, there's 1,001 things that can happen if you don't put it in there. Yeah, and you only follow us a couple of words. We are doing contract law, and we have to look at retrospective enforcement. And if you go and look at the deceased estates training we do, marriages, customary marriages, you'll see that marriages before this date operates like this and this and that and that and that. That's why we do it. So you can have a date you sign this, and if you want to say that, well, it's up to this date or beyond this date, or to at least at this date as amended, you can run then with that there. So that's your jurisdiction of Magistrates Court, and always use as amended. It's a habit. I do it with everything. All right, it's 1300 hours. Let's take a break. I'm going to put something down my throat, and let's back at 1307. 1307, what do you say about it, Mr. De Wet? Jonathan De Wet and Llewellyn De Wet will be back at 1307. Have a cup of tea, and then we'll take this further, and we'll see where we land today. Okay, now I gotta mute this thing. Let's see. There we go. Okay, I'll see you guys later. Enjoy. Okay, we're back. I think you can hear me now. So we'll just go a little bit into that other half an hour. Okay, first things first. Yes, exciting, isn't it? Drafting of contracts. It's fun, man. And really, really, if you're intimidated by drafting, through time and through experience, you'll pick it up. So don't feel intimidated. I mean, I was laughed at the first time, and that just made me say to myself, but you know what? You're laughing at me now. Watch me in a couple of years. And today, many attorneys contact me when they have a very complicated case and have to draft the particulars of claim. And then they come to me and they drop the boxes off there and they pay me the big money to work that POC out. So you'll get it. It's not intelligence, not being clever. It's experience and hard work. So yes, drafting is so much fun. Just a quick announcement. Like I said in the beginning, I accumulate all your questions. And then after the 2 days, I take a day or two and then I come back with full answers. And we've been doing that since last year and everybody is satisfied. I am not going to give you a 2-sentence answer now on a question. You can forget it. When you ask me a question, I'm an advocate and I feel you're actually through this institution instructing me. I take your question and I make certain that I generalize your question. So everybody gets feedback that's on the site. Everybody's going to see who asked what. And then I give thorough feedback so that you are empowered by knowledge. You know 100% what's going on. Because I don't know this afternoon in a constitutional court or an appeal court what the judge ruled on a certain thing, and then I might give you the wrong information. So I got my own way of doing things, and I'm an old dinosaur. That's the way it is. You need to get the right information because you've paid. You're listening to me. And in the mall, you're going to run into me and say, hey, but you are James Clark. And then I want to make certain that that's a pleasant experience. So let's go on then. All right, that's important there. We got to say that there. We locked in a little bit late. We had a chat outside here in the hall. Apologies for that. All right, so we were busy with the jurisdiction clause. And there was a question on a clause that came in, and I'll answer that for you. And you must send your questions through. We take a day or two, and we give you good feedback. And we do it in everything I do. I don't know how the other guys are doing it. That's how I do it. Okay, addresses for service. Now let's talk about addresses of service. Can you imagine that this is not in a contract? Can you imagine? So this is very important. And one of the interesting things here is that if you look at a National Credit Act, you look at a Consumer Protection Act, you would know that we have to use, language that is understandable to people. So you will all know this is what? Come and shout it out. Shout it out there. How about that, Mr. Chetty? Nirishoma Chetty. Yes, indeed, domicilio executandi. Is that correct, Mr. Amiri? Mrs. or Mrs. Amiri? That is correct. So let's have a look at it quickly because it's very important. You must always have the physical addresses in there, put the postal addresses in, build a telefax number in there and the email. Make certain you have all the possible contact details of the people, and especially if you do international contracts. I did a couple for Pravin Gordon a few years ago when he was still the Minister of Finance. I worked with his legal department, contracts between Europe and America. And there, by the way, on the advanced there, we dealt with the sovereignty clause. A lot of you would say, yes, of course, it's cross-border, etc., etc. What is important for me at the address of service clause is I've seen in many contracts, people just put in the party addresses and that's it. Look at page 11. Okay, all right. I understand. I understand, Mrs. Davids or Mr. Davids. I understand. I have to scroll down. Very well. There you are. All right, just look at what follows. Look at what follows. And I see a lot of people don't draft it in. Any notice or legal process to be served on either party may be served on it at the address specified above, and each party hereby chooses that address, so. And there they talk about registered post. There they talk about telefax. There they talk about emails. And the last one there is, if no specific agreement regarding email is concluded, then we will fall back to the Electronic Communication Transactions Act. So you've got to understand that your address of service is very, very important. And please take note, ladies and gentlemen, that your address of service may differ from your citation address. That's very possible. So please take note that the address that you put on the parties in the beginning of your contract is not necessarily going to be the same address as this. So what is this address about? And boy, this is interesting. When you challenge people, okay, what is this? What do you use this address for? And they don't have these extra paragraphs, and they usually don't know, they can't answer you. So, well, that's the place the business is. No, no, no. This addresses the service notices and papers and court documents and letters and correspondence and calling people, serve a document calling you out on breach, and you've got to rectify it in so many days, whatever the situation is. So this is what this is. So this can differ from the front page document. For example, holding companies and subsidiary companies. So sometimes you would put up the holding company and you would use this address locally here for the subsidiary company in terms of the Companies Act. Are you with me? Are you feeling me? And that's what that's about. So this is what that's about. So make certain that you utilize this correctly and understand what is the basis for this. I've seen this. A lot of people don't put it in at all. And they say, but hey, there in the beginning, there's an address there. So they don't really know what this is there for. All right, good, excellent. So we're still busy with the commenters. We're still busy with the boilerplate terms. We are drafting. We're really enjoying itself. Now, I just want to say something. Let's go back. I'm not going to page back electronically. Let's go to page 9. You can electronically page back to page 9 if you want to. Whole agreement. Well, if you ask me, it's got to be in every contract, except if you want to break it down. I can see that. So this is a whole agreement, except for maybe that and that and that and there. But the whole agreement has to be there. Variation, come on, come on. How can you go without a variation clause? People change their minds together. Maybe they say, but we've together decided we just want to change this. So variation clauses, if you ask me, they always have to be there. Relaxation of terms clause, I want to say it always has to be there because your contracts are based on terms, but that's not a full answer for me. I can think that most probably a relaxation of terms in certain instances will not be relevant, but 99% of the time I believe they will. Jurisdiction is very important to me. I mean, you all would relate because where is the contract signed? Who's got a jurisdiction? Not only to hear this. So this is very important for me, and you can draft jurisdiction in. So usually jurisdiction comes at the end where we signed on this and this date at Durban or a suburb of Durban or whatever the situation might be, right? But with jurisdiction, we can go a lot further. We can say we have consensus that if we have a problem in this contract, it will be held in the Magistrates Court, but also at this place. Make a note there. Make a note there. You have got to have jurisdiction in there. And please, ladies and gentlemen, also address international jurisdiction. Something I forgot to tell you. A lot of contracts are abroad. One of the last court cases I did a year or two ago was in Mandarin from China. Contracts Mandarin from China, but the court case could be here in South Africa. There's nice court cases on it, and I might explain that in advanced courses. But also deal with international jurisdiction, and then now we'll get to it later. I'll talk about the prevailing law of the country. So that's it, address of service. Now let's move on page 11, and I have to scroll there to legal costs. Now legal cost has got actually two main subdivisions. Isn't that correct, Simone Koen? Is that correct that you also have it like that? Mr. Esme Petit, is that correct? Mr. Preya Pillay, do you also have it like this? Legal cost has got a deal function. Let's look at it. First is legal cost for drafting of the contract. The cost of and incidental to negotiation preparation on page 12. Let's go down there. On page 12. Oh yeah, I'm the only one that can scroll down on the screen. I think that just loomed upon me now. Don't laugh at me. I'm a dinosaur. So when I scroll, I'm scrolling for you, I presume. Oh, okay. All right, okay. Don't send me rude letters. I now understand how this worked. My matric son is going to laugh at me. All right. All right, I get it now. I get it. Oh, what an idiot. The cost of an incidental to the negotiation and preparation of this agreement, including VAT and other payable duty, must be borne by the parties in equal parts. All right, guys. Finney's laughing at me now. It's not funny. All right. So what we have here is, please, this is so important. There's always an argument about who's going to pay for it. You must say who's going to pay for it. Sometimes the one party says, I'll pay for all it. And look at the VAT also there. Have a look at that and everything that goes with that. If you draft this in, you cover yourself. Because if there's one thing in my whole career I could never understand is the unpaid bills. And you don't always want to sue your attorney because an advocate has to sue his attorney. Although there's case authority that says something else, but we won't go into that now. But usually you have to sue your attorney and then he has to sue his client. If the client doesn't pay you. He didn't take enough money on a trust account or whatever the situation might be. So you don't always want to sue your attorney, and I've lost a lot of money. But if you do it like this, then you're covered. At least you're covered. You know who's going to pay and what the situation is. You can even draft in the fee if you want to. There's a lot of things you can do with this clause, but it's very important there that you get paid for what you are doing. All right, so that is important there. Please get this clause in there, because if you're a legal practitioner or a candidate legal practitioner, listen to me. This is important. You got to get paid. You've got to get paid, and I've seen you know how it goes with family. They ask you a lot of questions, or people find out you're a lawyer and advocate, and if they ask you questions in a Pick and Pay. But that's your bread and butter. That's how you pay your bills. So if you're going to advise them then a Pick and Pay, strictly you should be paying you $650 for that. You know, on your cell phone. Hey, hello. Confirm here on that recording device that I'm giving you advice now. You'll be still receiving a bill of $750. Do you still want to ask me a question in front of the bread or the meat place? Oh, not. Okay, fine. You see, we got to get paid. And in my career, this is the bad thing. We don't get paid. People walk away and don't pay you, and then you don't want to act against your attorney because your friend is giving you a lot of work. No. Start here with the contracts. Who's paying for it? Not getting paid for work. Do you guys agree with me? Fighting to get your money out of people, and you did your very best for them. Legal costs for litigation. In the event of any legal action being taken on this agreement, the successful party shall be entitled to cost on the legal practitioner and client scale, including VAT and collection commission where applicable. That's a very important one that you always have to have in there. And then we give you a lot of information there. Further commentary. We talk about the Rental Housing Act. We talked there about Section 23 of the Consumer Protection Act. Better have a look at that. We also mentioned Section 43 of the Electronic Communications Act. But what is important to me in terms of fees is there's a fight about Section 45. You all know it, under the Legal Practice Act about. And one of the biggest fights under the Legal Practice Act in terms of, you're going to excuse me, we're doing contracts, but my mind branches out and then it branches back, about the estimated costs. You know, one of the things you've got to tell people is, well, this is the estimated cost. This is the estimated cost for the advocate, which will tell you what the estimated cost is for your attorney of record. So there's an argument about that going on. But what I want to bring onto your attention, if you're a legal practitioner, look on page 12 and 13 for me. I'm scrolling down. There you are. They say the Section 45 also requires the specific information of giving a client relating to financial application, including fees, charges, and so on. Go through this. Your hourly rate, right to negotiate fees. Look at that, an explanation to the client of the client's right to negotiate fees. And we trained a lot of people last night to put up mandate agreements, which is contracts, attached to fee agreements. You've got to inform the people of the right that they can negotiate with, please, can you make it less to whatever the situation, that you know that you're supposed to put it in your mandate and explain that to people. And a mandate is a contract. The same heading, here we go. The whole thing I've been explaining the whole morning, the whole afternoon, I suppose. And that's what that is all about. And then do you see the likelihood of engaging an advocate? You're going to have to find an advocate, decides a junior, senior, silk, what the situation is there, the different fees of advocates. And then further, what do you ask for taking instructions, the FICA process, research? There you have it, drafting, the consultation. Now, okay, stop there. Oh, stop there. So freaking important. Guys, don't draft a contract without a thorough consultation. Whether it's electronic consultation over electronic medium, or whatever the situation is. I've picked up problems in my career with the following. The attorney of record phones me, draft a contract. I say, yeah, all right. He says, the client quickly over the phone told me to do this and this. I said, all right, so you are telling me this and this. Okay, send me an email. Maybe he sends me email. Maybe he says, no, just draft it quickly. I'm not close to where I can send you an email. And so many times I got it wrong, totally wrong. Goes back to the client. He says to the attorney of record, this is not what you say. Attorney of record comes back to me. And I say, but that's what you said, even in your email. Yeah, but you must understand. Bullshit. It's out of the door. You, the drafter, if an attorney of record appoints me as the advocate, I've had to draft contracts abroad in England and all of those places. And the other day I had to do one in Saudi Arabia. So what I do is I say, right, I want the link. And then I will reach out to that person in time frames. They tell me I can do it. Even if they get up 1 o'clock in the morning or 2 o'clock in the morning, I've got no problem with that. That's my job. And I enjoy doing it. And then you can always put on a white shirt over your PT pants. In any event, what you can do here, actually, that's the COVID way. You must have a full-on consultation. I should have said this in the beginning. I don't know why I didn't. Do not draft the agreement without a thorough consultation. Follow it up with emails. Follow it up with questions. Guys, if you make a mistake, they don't want to pay you. And then you feel like you're inferior because maybe you couldn't act instruction. Most of the times it's not the truth. So please make certain about that. And then, of course, people have to pay for consultations, right? Right, we are going there to negotiations where necessary. Negotiations where necessary. I wonder in my career how many settlement agreements I had to put up in court cases, in civil litigations, hundreds. So it's things that you've got to consider. Existence of presidents in office, online accessibility in the market. Presidents are always a good thing. I'm very proud presidents. And in the future, I want to bring out a president's a booklet, which guys can use on an electronic platform. There's so many things we can do to make the practice easier, to accommodate and lift the standard of service rendering, because we're giving you the president, and that's great. The same the Harms precedents, which I use a lot in POCs. Time required for all attendances. Who in the office will be contributing their time? Is it 2 attorneys, a senior attorney? Are you going to have a consultant with you, whatever the situation might be? And so please go through all of these things and make certain that when you draft your legal cost clause, because this draws back to that, this is all in any event a considerations that you have to take into account when billing. And then we give you a lot of their things there, talking about misconduct and all of those things. You can go there in section 35 sub 7. You can work through that in your own time. All right, on page 14. In page 14, and I think I remembered the scroll. Oh, I did not. So there we are, page 14, we're going to ADR. All right. Alternative dispute resolution, negotiation, mediation, and arbitration. Negotiation, guys, I'm not going to go back to 101 university with you. Negotiations, 2 people are just talking about, it's not binding. Mediation, 2 people are talking to each other with a third guy that's just mediating, it's not binding. Although with mediation, you can go into a contract that contractually say, okay, stop the bus, I'm branching out. Okay, guys, I need to teach you something again. And this is very important. It is called the law of the content of the contract. The law of the content of the contract. Because I'm saying to you now that mediation is not binding, but I'm also saying to you that if you have a clause in your contract that says, well, mediation will be binding, then it's binding. What am I saying to you? I'm talking about the law of the content of your contract. We all know what color the sky is, right? But let's say I give it a ridiculous color in a contract that it isn't. For the purposes of that contract, the law on the content of that contract says it is that ridiculous color, not the real color. All right? If I take a word out of the dictionary, Oxford Dictionary, and in a contract, I change the definition. Which definition is the right one? That's it. The one in the contract, not the one in the Oxford Dictionary. That is the law on the content of the agreement. So with mediation, I'm saying that you can make it binding there in a clause. So this is very important that you grasp it. A lot of people don't grasp it. And do you know where I've picked up in litigation problems with this? So usually people would appoint me and say, well, you do the case, draft the POC, do everything. Okay, I'm getting old now. I'm just doing selectively cases now. But I like still to do all the drafting. You can see it all your drafting. I love it. But what I usually do is I'm amazed that in the contract, we have just said what? Page back to the legal cost clause. Let's read it. There on page 12. In the event, paragraph 3962, in the event of any legal action being taken on this agreement, the successful party shall be entitled to the cost of the legal practitioner and client skill, including VAT and collection. So sometimes we would write the attorney and own client skill. Sometimes we write attorney and client skill, party and party scale. Oh, stop the bus, where it's legally relevant. All of these cost orders and certain contracts and certain things we do is not relevant. Remember that you cannot just ask for cost in a contract. You must go and see if it's allowed in the sense of that service you're rendering. There is things that's going on there. that you have to look at. I bet a few of you didn't know that. You think you can just select what cost is relevant. No. Make certain that the cost you're relevant for this clause is relevant to the service you are delivering here under. But what am I saying? I'm saying I don't understand the civil litigation part of this. Because what happens here is we go to the court, we are suing in a POC, whatever the situation is, and then we say cost in the cause, or attorney and no client cost, and then we hope that the discretion of the court falls into our lap. But why are we doing that? There's a contractual law within the contract that says that if there's a breach, this is the award we agreed will go to the winning party. Then you ask that in your prayers, not this other nonsense. And I was so amazed that all the attorneys I work with, they just go for cost in a cause or whatever the situation might be. But the contract says when you do it, there's a law in the contract. It says that that is what I'm entitled to. We agreed upon that you enforce. Okay, a lot of you didn't know that. And then, of course, my senior colleagues. I apologize. I know you know. But it's always been for me so strange. I would look at a contract in court and I would look at the press that some attorney has put up, and now I'm on the case. And I would think by myself, but the contract says attorney and client, and here we are going for party in the pressure. Well, what's this all about? Then I would phone the attorney and say, why was that? He says, oh, no, just draft it and put party in there. All right, enough of that. You know what I mean, eh? So that is the weirdest thing. That's the law, and it must be abided with. That is the law of the content of the agreement. That apple is green, but the agreement says it's red. It's red. All right. Just don't do things that's illegal, obviously, and so on. All right, look at page 15. 15, that's negotiation and mediation. Move on to page 15, the arbitration clause. And do you see, Cecile, if you're online, this is why I say this is relevant to everybody, because I branch out and I branch back to the guide. So this is why we are, that I always say, all people man sitting. In any event, you're going to get a lacquer certificate, if I'm not mistaken here. And that can just promote. Okay, if you're one of my senior colleagues listening now, is only smiling. But for the guys that are starting out now, those certificates and the training at this institution with that brand name is immense. So that really, I stand behind this brand. All right. So arbitration, there's your arbitration clause. There's only one thing I want to say about an arbitration clause. We'll go through it now a little bit. It's not necessarily go through the whole thing, is that it's expensive. Talk to your clients. Don't push your clients into arbitration clause and later where they have to dish up 200,000 Rand or R1 million or whatever the situation is for the forum, and everything happened here with the arbitration that they're upset with you because you never told them. The first thing before you draft the arbitration clause into any contract, you say to your clients, this can be freaking expensive. It's more expensive than rather going through the court. Okay, it's informal. Although I don't know about it, because all the retired judges, if I appear in front of them, I use the same respect in court. So I've fought for years about that. You know, I'm not going to disrespect the retired judge. Are you mad? So have a look at that and tell them it's very expensive, and then ask them if they want it in. There is corporates that wants this in, and etc. etc. Then look at the content of this clause, of this arbitration clause, and decide. Don't just copy and paste. No, I'll talk about copy and paste tomorrow, guys. Copy and paste. We do, I know. But be careful. I've been embarrassed once in a contract like this. A friend client of my phone back and he says, who's that? And I said, yeah, okay. I copy and pasted that clause over and I forgot to take his name out. And I'm asking him a fee for a contract. And what does he think? He thinks the whole contract was pasted in 2 minutes, and I ask him 50,000 Rand for a contract, because that's the impression I'm creating by one stupid little mistake. So copy and pasting. Okay, so now I've said it. Don't have to say it tomorrow. So arbitration, look at it on page 15. You can build into your arbitration clause what you want in there. The interpretation and the carrying into effect the parties' respective rights. It does not have to be this. So now we are arriving on another platform. I'm empowering you with knowledge. Maybe you were already empowered by knowledge. You have it already. Just want to recap on everything. But now you're an independent thinker. I'm telling you, you can change this. You must be an independent thinker. You must decide as you gain experience, hey, do you agree with us here at Lead? You might not agree with me on everything. You might say, I don't agree with that. That's your right. Guess what? You might be right and I might be wrong. So you're an independent thinker. So those are things you can build in there, and you can decide what you don't want to build in there. Then you can go down on page 15. That is the, no, that's not what I'm looking for. There on page 16, paragraph 1.5. You can go there. That is the level of experience. You'll see there that if this happens, it's a 10-year practicing counsel as a 10-year accountant, and so the story goes. You can put 5 years, you can put 7 years, you can put 15 years, you can put 10 years. These things are up to you. You're an independent thinker. You have a book in front of you. This is not set in stone, except where the law sets it in stone for you, and this is what you have to do in the National Credit Act agreement within the ambit of the NCA. That's different. But here is things that you can utilize and you can work around. It's very important, I'm saying to you. When people goes into groove, I'm Advocate Clark, I've taught you something. Now it has to be like that. Nonsense. You might be a junior attorney and you might be able to teach me something totally. All right, we're going on. We're going on there. So that's everything about arbitration. And then, of course, there at the bottom of page 16, let me scroll there. At the bottom of page 16, I think this, yeah, that's Friday. There it is. I just want to read that to you. Clients should be warned that arbitration clauses might only be effective if the lease agreement had not been cancelled prior to the relevant dispute being determined in that court case. And then they talk about that. I would just like you to go and read that. I've done a lot of lease cases, and for some reason, everybody always opts for arbitration clauses and lease agreements. Now, with commercial properties, great idea. I mean, those guys got billions, but you sure as heck not going to do this for the natural guy in the street that just wants to buy another person's car quickly, second hand. That's not the road you're going to embark upon. So please have a look at that. That is important for me. I wanted to bring that under your attention there, because in terms of commercial leases, you're going to look at these things. And you must know there that you can see there it's a Tutabantu properties versus Summit warehousing. So just need to take note of that. And also take note of it that you use the court cases when you draft commercial leases. I've had clients that has built malls that ask me to put it up. And then you have to take all of these things into consideration. All right, so that is all about arbitration. On page 17, you'll see we are telling you more about it there. We're talking about the Rental Housing Act, the NCA, the CPA. And just for those people who don't know, ADR, Alternative Dispute Resolution, important for me to say that. And then also, under negotiation and mediation, there is now a new market. Is that correct? There's a new market, am I right? Mr. Nereanki or Mrs. Nereanki Lombard, and I see I've got Mapiela, Amare, and Mare there, two Mares there. Am I right? Am I right? There's now a big market out there because through mediation, that's right, within criminal and civil litigation, there it comes now. You know, you're going to be putting up a lot of settlement agreements. And if you don't put up a settlement agreement, you've got to indicate to the court that it was considered parties didn't want to do this. There's a whole process you have to follow there. So there's a new market out there for a mediation. And the new legislation there and the court rules there that's talking about it. Make a note that there's a new market there. Go read up on it. Go read up on it. There's a market there, and you're going to have to be drafting a lot of those things in the future if you are into civil litigation. And maybe you're not into civil litigation, because I see a lot of attorneys branch out. They'll ask another attorney or an advocate to set those things up for them and to get it done for them. But there's a market out there. This new legislations in terms of mediating problems and so on. And there's actually a court case I looked at this week, a maintenance court case or something, that says there will be mediation in every such case before it proceeds further, or an indication that mediation was unsuccessful, or that the parties just flatly refused it, and so on. But actually, those people were chased out of court by that judge. I don't know if it was Van Niekerk, because he's come out with some good rulings. Okay, still with common terms, still with boilerplates. We are not gone. We've not gone away. We are still with common terms, still with boilerplate clauses, and you can indicate it like that in your contract. You can say common terms, and then you just subdivide it in subheadings, all these clauses we've been working through. Now, ladies and gentlemen, the breach clause. The mega clause of all clauses, if you ask me. I've been invited, or let me rather say instructed by attorneys of record to attend to cases, contracts, corporates, big cases. And then I ask the contract, I go through the contract and I ask, where's the breach clause? And then you must see the finger pointing. And then sometimes, if you don't have the breach clause, then I have to just build a case on a foundation without it, and I rely on reasonableness, I rely on discretion, etc., etc., and so on. And the breach clause is imperative. If you come to me with a contract and you don't have a breach clause in it, or multiple breach clauses, am I right? Where's my learned colleagues there? I cannot see who's learned here, but surely there must be learned colleagues. I know Cecile is a learned colleague of mine, and we will know that sometimes in an agreement you can have multiple breach clauses on different things. We also know that you can have a breach clause and an arbitration clause in the same agreement. Make a note there, you didn't know it. But here's the problem. Most of the clever guys try and do it. They build the arbitration clause into the agreement, and then they build the breach clause into the agreement. And what don't they do? They don't say when the breach clause will be applicable and an arbitration clause will be killed. They copy paste, I'm good. I've got an arbitration clause and a breach clause, and you can't do that. They're going to fight each other. You got to say when which one will be applicable to what. And in the arbitration clause, you've seen you can say what there, and then in the breach clause, you can say something else there. And I can already think of 1,000 reasons why you'll have a breach clause and then suddenly you'll fall back to the arbitration clause and suddenly you'll fall back to the breach clause. Or I can think of a lot of reasons why the arbitration clause will only address certain problems while the breach clause will address other problems. So you can have both of them in there, and that is very, 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 very important to know. Isn't that correct, Arlette Prinsloo? Do you agree? She's nodding her head. I'm lying, I cannot see her. Right, breach clause, let's read it. This is a good breach clause. I don't have a problem with this breach clause. In the event of either party being in breach of any of the terms of this agreement and failing to remedy such breach, within a period of 10 days after received by it of the written notice requiring such breach to be remedied, the party aggrieved thereby shall be entitled, without prejudice to any other rights which it may have in terms of the agreement or at law, if you can bold in your book, without prejudice to any other rights which it might have in terms of this agreement or at law. All right, so make that bold, because that gives you a gateway to something else if you want to go in that direction. And it doesn't kill you. This breach clause doesn't kill you. If there's other remedial processes to be followed within this clause, you can branch out. It's a lot of people don't put this in. So just without prejudice to any rights which it may have in terms of this agreement or law, and just make that bold. That is so freaking important because it opens the door wider to address problems. Right, claim specific performance of terms of this agreement, as well as such damages which it may have suffered. There was a time, do you remember, my senior colleagues? With that, I don't mean you're over 80. Years ago, you could not have specific performance and damages. And I don't know why we come from that area, but let's call it a development through the ages of our years. Now you can have them together. Cancel this agreement and claim and recover damages, same principle. Keep this agreement in force. Listen to this. Keep this agreement in force and recover such damages as it may have suffered as a result of such breach. And if you're even a junior legal practitioner, common sense prevails that you can ask damages with these. Go and consult your newest editions on Harm's precedents, and you'll also see what's going on there. So it's very important for me to bring this breach clause under your attention. Please, I've seen so many agreements that doesn't have it in there, and it makes litigation that so much more difficult, because then you have to, and in any event, then you have to set up that letter of demand within reasonableness. You've got to follow that whole road down there. All right, so there's a couple of court cases there. We see the Burgundy Rose trading case versus Bressler. It's important to be very clear as to what obligations there are on contract parties. A breach of contract clause will not be able to be enforced where duties imposed on the enforcer within the breach clause have not been complied with. Common sense. Have a look at that. Have a look at that case there. Also see the development CC case with ACE. Where the party relying on a cancellation clause was prevented from relying thereon as the procedure in terms of the specific contractual clause, one of two cancellation clauses in the relevant contract has not been complied with. Common sense. Now, this I've seen a lot. People storm into your contract, say, right, issue that summons. Now, advocates read. I'm not saying attorneys don't read, but counsels are paid to read. Let me rather put it like that. So what I do is I remain quiet and I read the agreement and I look for certain things. And I read and I would say, whoa, stop the bus. You cannot issue summons. We have to go through these procedures before we arrive there. And then you have an upset client. As though it's your fault. Eish, eh? Love them when they pay. Hate them when they don't pay. Eh? Right, so going on there. There's a couple of more court cases there. I would love for you to go through them in your own time and have a look at them. They're the common clauses. We haven't thrown in here things that's difficult. I mean, come on, it's logical that the contract says before you can arrive here, you must do this and this. And then, of course, you also get people that they do it, but they do it halfway. For example, let's give you a stupid example: evictions. Then you would have these property companies. They issue the eviction notice themselves. And then that eviction note, and now they have to evict. Now they pass it over to attorney. I've seen that in many eviction instructions I've received. Then I throw it back to the attorney and say, whoa, stop the bus. Look at that eviction notice. You gave them 15 days. Yeah, I hear you shouting. You're quite right. So you either give them 21 business days or 30 calendar days, something like that. And you do it right, and you make certain that at the end of the month, you tell them what kind of days is it. You can't throw them out in 7 days. The judge is going to give it one look and he's going to erupt upon the council, and that's uncomfortable. All right, guys, that's good. We've got till 30 minutes before we eat 2 o'clock. So we're still going on there on page 19. Yes. I know. I have not scrolled. I know, Tatu and Luke. I know. All right, there's governing law. Excellent. There's governing law. I want to talk about this. The agreement shall be governed by the laws of the Republic of South Africa. That means that even if this contract is in Namibia, a Namibian court, for example, will have to apply the South African law. And I had a case like this from China and Mandarin. You can imagine how difficult that was. We had to get translators. And the best part of it all is it seems that in China, different kinds of Mandarin is spoken from different provinces. So we got one guy to translate. We were not satisfied because our client was telling us this is what it's saying. We got another guy and he says, no, it's all right, but it's actually saying so and so. And you know, when we litigate, that is very important. So on the governing law, make certain that you build this clause and you say where this is happening. You've got a transport company and it runs its trucks from South Africa to Namibia to Botswana to Mozambique, etc., etc. Then you have to decide where you want litigation to be dealt with. And that's important. Joint and several liability. My first problem is here, there on page 19, right? I'm scrolling there on page 19. You will see we have a clause there, joint and several liability and severability. That is interesting. That is very interesting because I've seen that people confuse them and don't know the difference between them. So let's get this out of the way and let's quickly deal with this. Joint and several liability. The debtors, tenants, consumers, or other applicable parties are jointly and severally liable for all the obligations, the one paying, the other to be absolved. And that's what that means. And where do you use that? Where do you use that? Can somebody tell me out there? Mr. Thompson and Mr. Taljaard, or Mrs. Thompson, Mrs. Taljaard, I don't know, I'm just quickly looking on the list. Can you tell me? It has to do there with your prayers too. If you have a first and a second respondent, more than one respondent, depending on what you're claiming and you feel this is relevant, you'll ask it in that manner too. Am I right? So let's quickly look at what's the difference then to several liability. Come on, guys, you must pull the line. Let's pull the line. Pull it with me at sever. Pull a line through sever at 3.9 level before you go to ability. Now, what does sever means? It means I am cutting something away. I'm going to cut something out. I am a surgeon. I'm a legal practitioner surgeon. I'm going to cut something away. And that's the difference. I see also in exam times, students mix these up. And without, of course, sometimes not knowing what this is all about. Let's quickly have a look at it because it's very important. Because it stands between your contract being totally declared illegal, null and void, whatever the situation would be, or just that piece that in law under the National Credit Act, for example, that is problematic. Each clause or part of a clause in this agreement is separate and severable from the rest of the agreement unless severing would render the agreement unlawful or it not be reasonable to do so having regard to the price, the clause, or the agreement as a whole. And you're going to decide in what direction you are going. And you have to build that in, which is in brackets. Don't play games for contracts. So this tells you that, okay, we can save this contract. Except if taking this clause out defeats the purpose of this contract, then a court is going to say to you, sorry, we're not going to allow it. Should any clause of party off be unenforceable, it will not affect the enforceability of the rest of the agreement, unless severing would render the agreement unlawful. It would not be reasonable to have regard to price clause. And that price and stuff, there you can just build in what you want to build in. And ladies and gentlemen, now it's easy, isn't it? So that's when we sever. That's when we cut away by law, and we do it legally, except if we're in a situation where we cannot do it. You cannot read a contract without that clause. And then a court, and there's a lot of court cases on that too, if you want to research that. Still with commenters, still with boilerplate clauses, confidentiality. Yep, come on, don't forget the scroll, there you are. Confidentiality, the parties agreed to keep the content of this agreement confidential and undertake that they will do all in their ability to protect the confidential nature of this agreement. Ladies and gentlemen, a lot of you think this is just a clause. I actually, in the year before last year, I had a court case on this and it was extremely difficult. Extremely difficult. There was golden handshakes in a company, and when these and shares in the company were involved, and it had a clause like this in it, and then there was a arbitration. Our client was under this confidentiality, and the attorneys couldn't resolve it. I sat 2 to 3 weeks with it until suddenly I saw a word in the clause, just a word. And I was able to build on that word an argument that prevailed. So be very careful. It's not just a clause. It can have detrimental consequences because obviously this corporation was taken over by another corporation and they didn't really want to know how they ostracized, if that's the, you know what I mean. The other senior members of the other company, they pushed them away there in the corner. They forced them actually to go away. And then they made golden handshake deals with them. And they had this confidentiality clause in there. And then they wanted our client to come back. Another person wanted our client to come back and help him break the confidentiality clause to go up against them again. And for a couple of weeks, we couldn't do it until one day I looked at it again and I saw a small word. And I thought, but wait a minute, I can work with this. And then it went in the right direction. So this is not just a clause. Please have a look at that. Execution of contract. The parties undertake to do and procure whatever is needed to implement the terms and conditions of this agreement. This is a very important clause when you buy a house. Am I right? Where's my conveyancers? Am I right? Am I right with this? It's a very, very important clause when you buy a property, because there you would write that everybody have to sign all the relevant documentation to make certain that this contract is going forward. So execution of the contract can amount to a breach, because you buy a house and you don't want to buy the house anymore after you've signed a contract. You just stay away from the conveyancing attorneys. They can actually, under this clause, interdict you. And again, if there's damages, they can go in that avenue also. And then, of course, on the top of page 20, we say another way of drafting to ensure cooperation would be include the best endeavors or reasonable endeavor clause. And let's read there. The parties will cooperate to use the best efforts to ensure that party A is able to trade 24 hours. The best efforts to ensure. Do you see that? We'll use all reasonable endeavors. Do you see that? To keep all the access routes to the trading premises of A open. So this is a clause that in the South African law, this specific endeavors clause, I have actually introduced it in that other book you phoned to buy. I see a lot of you guys want to buy that training manual now. And I'm happy about that, because you learn a lot from that. And I think I've introduced it there. That's why it's here. And it's a bona fide undertaking. Now you get it, right? You didn't know what I was doing here. So this is the bona fide undertaking. And yeah, you can litigate it. If you can prove mala fides, there you go. Right, guys, we're going on. We've got enough time. We're going on there to page 20 to counterparts. Counterparts. We're still with common terms. We're still at a boilerplate clause situation. And I will recap later on. Counterparts. The parties agree that this contract may be executed in a number of counterparts by the parties. Should it be signed at different venues or different times, or not at the presence of any other party, will be deemed to have been signed as if the parties were all present at the time and place of signature. And I've had problems with this before. What I always recommend is that what I try to do is, if there's 4 or 5 people that have to sign, I write the train. You can write down there or type in there, we write the train. So I will write, I will draft the email to everybody and say, guys, we're going to sign this in sequence. This guy is signing, he's scanning it back to me. I want to look at his signature. I want to look at his date and his place. I'm going to send it to you, then it comes back to me, and that's how we do it. Or you can write a train and you can trust him to do it itself, or you can send it all back out. They all sign it. And then you are stuck with all these agreements coming back in a file to make up one agreement. And so there's a way, a bunch of ways you can do it. I like to take the long road. I write the email and say, right, I am the pinnacle point. We are not going to sign different documents. And then I start and I bring it back, send it out, bring it back, send it out, bring it back, send it out. And what I do is I keep the emails, and when it's done, I take all the emails because it's got on the second times there, and I attach it to there. That's how I do it. Maybe you've got a better idea. You're more than welcome to tell us. And by the way, guys, if you don't know, after these 2 days, I'm going to look at your questions, but you're more than welcome to say, hey, by the way, I've read this, and I think this will be nice if you want to present this in your presentation too. I don't mind. You can be a junior. I don't care. If I can learn something from you, that empowers me. I'd be stupid not to do it. I'd be a stupid advocate to think because I'm an advocate, I know everything. And when you catch me doing something that is not correct, I insist it's correct because I've got the title of an advocate. What idiocy is that? So yeah, you can make recommendations. Maybe you want us to circle something in the group that you think is interesting. Please just remember one thing. This is a beginner's platform. All people can sit in and learn something here. But if it's too complicated, I'm going to keep your question. Hopefully you register for advanced. All right. Annexures, page 20, scroll down. This scrolling business, it's almost like drinking. Cool drink. I wasn't talking about anything else. Mr. Weppener, Ernst Weppener, I was talking about cool drink. What were you thinking? All right, annexures, paragraph 3.10 there on page 20 is actually where I wanted to land. I want to actually finish up to page 21, and then we can call it a day. What do you guys say? We call it a day, eh? I just want to talk about, maybe I'll end before signatures. We'll just see, because signatures is kind of important to me. We got to talk about that. Annexures are very important. And if you know the National Credit Act, you will know that the days that you can just refer to annexure is now illegal. Is that right? Is that right? Do you concur, all of you? You have to now, at least in a clause, when you refer to annexure under National Credit Act agreement, you've got to at least explain what the surety is about, or whatever you annexure there. So that's important for you to bring under your attention. And what I've now come into the habit of doing is, because the National Credit Act is just guiding us, everything is going to follow. And the good and normal language for the layperson has followed in all things. It's all going to follow. You might as well start doing it now. So what I'm doing in all contracts I'm doing, I have an annexure clause now in my contract, official annexure clause, usually at the end. Official annexure clause. And what I do there is I say, okay, annexure so-and-so, and I give an explanation. I do it in all my contracts that attach here a surety between so-and-so, and I give a little bit of information about it. So that is what I'm doing. And I see I write a recent legislation, for instance, the National Credit Act. I think we can hardly refer, let me put a cross through there. I think we can hardly refer to the National Credit Act as recent. I mean, that's just the way it is. All right. So that is where I have arrived. All right, guys, I see it's 2 o'clock on the dot. I'm contemplating quickly doing that. Okay, I'm going to quickly just talk about paragraph 3.11, and then I'm going to stop because I've got all right. And this is actually a place where you can ask questions, but we're not going to do it in all of them. I do it in another way, and the people appreciate that much more. So I'm going to be finished with you in a couple of seconds. So I'm telling the back office here, Steph Petersen, pilot behind me, Merlin September on the other side, and quality assurance, if she's still online, that in a couple of minutes this is over. All right, dating and the location pertaining to the signing of the contract, 3.11. Yeah. I sit in boardrooms and then we're going to litigate and I page through the contract and I say this contract is not dated. And then tomorrow I'll talk about the fact that the contract is not signed. And the first thing you get said is, that's impossible. That cannot be. And then I take the contract with the necessary sarcasm it deserves and I flick it over the boardroom table and I say, see for yourself. And then I ask the next question. Did you draft it? Oh, the games we play for fun. In any event, you need to sign and date it. It has to do with jurisdiction. It has to do with prescription. It has to do with so many things. And please, another thing I've picked up with templates is the year 2020. Do you see this 2020? So what I've picked up with templates, you should actually now in this guide read 21. I'll see that it's changed. That recent legislation is taken out. What happens is that people paste and copy from other contracts and then the year they don't sign. Now, one of the ways I can fix this is if there's email substantiating the allegation in front of court, say, well, it's a mistake. We have emails and this email say that this contract was reached in 2021 and it says 2022. So it's very important, ladies and gentlemen, that you do this right. Signing on the date, give us the jurisdiction. Is it Johannesburg? Is it Rosebank? Specific suburb? Give us the jurisdiction there, and the month and the date, so that there's no problems with that. So that is very important to me, and that goes hand in hand with signatures. But we'll talk tomorrow about signatures, because if you give me a contract to litigate upon, it's not signed, it doesn't have dates on. I know that I had about 2-3 years ago a case like that where I asked the guy, do you have emails? He says, yeah, we got a lot of emails and we have an email in which you said, okay, we all agree to this agreement now. And that's how I got that case going. But this is the stupid and dumb things we do as legal practitioners, and we shouldn't do it. For the other people out there that's not legal practitioners listening to us, well, now you're learning. You're learning. But then I got to tell you, I've met a director or two in my life that's not an advocate and attorney, but those guys know their stuff. They could tell you more than legal practitioners could tell you about contract law. So I've also been down that line. All right, guys. That is that there. They say there at the bottom of that, be careful with the dating of the agreement. If the agreement has a cover page, it will likely contain a date, and contract footers will in many cases also contain the date. Not always. I don't agree actually with that. Furthermore, the signatures words of agreement will often also contain the date of many signatures. Signatures will, despite the fact that no space is reserved, write the date next to their signature. No, 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 no. You must make allocation for that. Don't let the clients that has to sign decide now what they have to do. Make the spaces, make it clear what they must sign, where the witnesses must sign, and all of those things. We look at that tomorrow, and we'll take it further. And then the last piece there on the top of number 21. Any such dating description also due to logistics. For example, if the closing date of the transaction slips by a day or two from the scheduled date, the parties might prefer not to change the date in each of the transaction documents. And when one party signs a contract on a given date, then sends the contract by courier to the other party to sign. I'm not going to go into that. What I am going to say here, and I have to say it, make a note there, let's talk about the signing date versus the effective date. There you go. All right. You get a signing date for a contract, and most of the time that's the effective date. But let's talk about building contracts with phase dates. So that's not always the case. So a lot of time people will sign on this date and they will say on a future date, this contract will become effective regardless of the fact they've signed it on this date. And I've done a lot of building contracts in phases where we put out the cutoff dates for every phase, the foundation, and we do something with it. And that's also effective dates for phases within a contract. And we signed this contract today, but this house, they're starting to build it within a week on that date. Then we go into the phase dates, and it will be handed off at this date. And that is why you need a variation clause. Do you see now? That's why you need a variation clause, especially with building contracts. Yeah, how many times the parties has come to and say, we need to vary this. This is going to work for us. I've got to build them 10 houses and suddenly I'm running into problems like COVID and I don't know what else. And the other guy says, yeah, I understand it, but we have this contract. I ain't moving if we don't do this legal. And then we jump in and we address that. And that, ladies and gentlemen, brings me to the end of today's presentation. As usual, I have thoroughly enjoyed it, laughed at myself, you also maybe. And that then is contracts. And I'm sure that even if you are a seasoned contract person, there must be something that I said that maybe you have forgotten. You think I better start looking at that. So I'm finishing up with the following. Heading. Do something with it. Parties. Do everything with it. Whereas we all agree in bold fat letters. Index if necessary. Preamble. Specific conditions. Legislative. Common terms. Annexures. And end off with dating in place and go into signatures. How can you go wrong? This is it. It doesn't matter who you are. Doesn't matter what contract you draft. How will it dramatically change from this chronological order of contracts? How can it dramatically change? I cannot see it. This is the road you take. And if you take this road, you'll pick up experience. And yes, sure, there is other things you draft that doesn't fall into this category. I know that last year during COVID, I had a very good instruction on a promissory note. A promissory note with a session. That's right. A promissory, and I had so much time on my hands due to COVID. I actually put up a free page agreement there, promissory note with a built-in session. That was enormous. And I don't think there's another one in the country. I had all the time in the world to do it, and I enjoyed it so much. This is enjoyable. This is fun. And you must enjoy your work. You must enjoy your job. And drafting is only a pleasure. I'll see you tomorrow, same time. Send in your questions. Hopefully before the end of the week, we'll have answered them all. I'll see you again, same time, same place.